in the matter of InterDigital Technology Corporation and others, and Lenovo Group Limited and others.
So I'm going to move to the cross-check. So that's ground C. It's covered in our skeleton from paragraph 56 onwards. And I've already foreshadowed what's involved in a top-down analysis, particularly where it's used as a cross-check. What you're doing is working out what royalty you'd have contemplated actually suggests the overall royalty that would be payable for the whole standard.
Am I right in understanding this is supportive of your case on grounds A and B rather than independent of it?
Yes, and that's why it's a cross-check.
Yeah.
Absolutely. Now, when you're doing it, as I foreshadowed, you need some measure of what fraction of the overall pie the portfolio you're concerned with represents. And in this case, studies from PA Consulting, 4 I think it was, plus 1 from another firm we use. And we see in the judgment at paragraphs 826 to 829, so that's page 21 of the bundle. The judge sets out and highlights PA and their reputation and their investment in their reports. And he also said he was prepared to assume the reports provided estimates of InterDigital's share of each generation of technology. That was para 838. So you go forward to the bottom of 204, you see him say that in 838. And he put numbers in the table at the foot of the page. My lords can actually see there are in fact 3 4G reports, 2 from PA and the other from CC, the site created, pointing broadly to a share of around 9% for 4G, and very similar for the 3G share of 9.5%. And 5G is about half that. But on any view, my lords, a very significant share of the entire pie. Now, the point of a cross-check is to sense-check the output one gets from the comparables approach, as I say. And the rival positions between the judge were obviously Lenovo's contention and my client's contention at the time. And the judge hasn't accepted either, but he does explain what the number he's come up gives you. And as things have fallen out, with the judge preferring Mr Mayor's unpacking, but also with the discrete dispute over excluding the effect of the heavy discounts, the judge has come up with 17.5%, and as my lords know, on the point of principle, the distinction between the two positions would be 17.5 one way or 49 or 50, depending upon whether you apply both of those adjustments, the economic adjustments. But you exclude the heavy discounts for the past. And what we say the judge should have done is test the two approaches with the cross-check. That's the point of the cross-check. This isn't a case where the comparables admit of no other analysis other than the judge's. There were 2 rival contentions before the judge, and in fact, from the numbers that I've just given, my lords, you know that they differ by a factor of about 2.8, so somewhere less than, but approaching the factor of 3. And that's exactly the kind of discrepancy that a cross-check should be capable of exposing. But the trouble for the judge is he just didn't do it. He simply rejected the cross-check itself because it didn't tally with his preferred view of the comparables analysis. And he did that even though his preferred comparables analysis gave the overall royalty stack of less than 1% for the entire stack. And that's important, my lord. He basically rejecting the cross-check because it didn't agree with the thing it was supposed to be checking. And can I show you that? Can we start at para 848? So the foot of the page, 206, and then it goes over to 207. And the judge sets out what the royalty stack is for the whole. This is for 4G. And the answer is less than 1%. While we're here, please note the use of the industry average selling price. That's an ASP of $220 for 4G, mentioned in para 848. You see that the number is less than 1% for the overall stack at the top of page 207. And the number for 3G on Lenovo's case, this is him working out the numbers on Lenovo's case, which I'll explain to my lords in a minute, was very similar, and he accepted it was very similar. But the number for 3G on Lenovo's case was 3.86%. We see that at the end of para 850. As the percentage share for the stack for InterDigital is very similar to the 4G share, I think that must come largely from the significantly lower industry average selling price for 3G, making the same amount in cents a larger percentage of the lower value handsets. But those were the two numbers, less than 1% for 4G and 3.8% for 3G. That's what the judge was getting for Lenovo's case. And that was 16 cents, so very close to the judge's 17.5 cents. And the judge recognised that his royalty would give only slightly above the figures calculated for Lenovo's case. And it's obvious, my lords will see that it's larger by a smidge, a factor of 17.5 over 16. But that's still well below 1%. I think the total stack for 4G on that approach would be something like 0.84%. So my lords, even when multiplied by that factor of 2.8 to represent using the 49 or 50 cents of my case, still a very moderate overall stack, but much more reasonable. And in fact, if you multiply the 3G number by the same factor, 2.8, you get a slightly high 3G number. And so on my case, you get numbers where you get a slightly high 3G and a slightly low 4G number when you multiply up by 2.6. But in fact, that's actually the kind of thing you'd expect when using a single DPU price for both 4G and 3G. As I explained, you're deliberately saying you want the price to be a bigger fraction of the lower priced handsets and a higher price, a lower fraction of the higher priced handsets. But both, on my approach, in the right ballpark and straddling what one might think is the reasonable range. And my lords, the point of a cross-check is to do precisely this. Check the sense of the number that you're getting, particularly where there are different ways of extracting the information. And you see that one gives a sensible overall stack and the other doesn't. And the judge's overall stack of 0.8% for 4G and 3.8% for 4G doesn't compare with what one might consider reasonable. We give my lords some numbers in para 60 of our skeleton. We give you my Lord Justice Birss in On My Private Planet, Judge Sellner in TCL, and even the 4 to 5% in the Chinese case of Huawei and Conversant, a jurisdiction that is generally considered low by about a factor of about 2. And you see those numbers are all in the higher single digit, leaving Conversant is around 4 or 5, but the others are up somewhere between 8 and 6 or up to 10, I think, the Sellner one, it gives a range. But what you should be looking for is something that looks about right in that range in my submission. And if the judge had done it, he'd have seen, it would have exposed that his approach didn't pass the sense check, whereas excluding the depression from heavy discounts for the past would have done. And so, my lords, we submit, as we say in paragraph 61, one might have thought the point of the cross-check would have been to cause the judge to pause and think, but it didn't. And I'm afraid his view that it didn't match the number he derived was his principal reason for rejecting the cross-check. My submission is that's rather a circular approach. In effect, his approach was, here's a method to sense check my results from the comparables to see if other contenders are more sensible. It tells me my approach isn't sensible, so I reject the sense check. And I do so without comparing what it tells me about the other approach. Can I show you that rejection? If we move forward to page 214, the judge has, by this point, rejected the hedonic regression way of presenting the top-down cross-check that I mentioned right at the outset, which needn't trouble my lords. And you can see he moves to consider the much simpler top-down cross-check at para 880. And after mentioning the rates considered in other cases at 881, the judge says he's unconvinced by the top-down analysis, and his principal reason is, as I've just foreshadowed, because the comparable analysis doesn't provide support for the rates that the top-down case supports, he's rejecting the top-down case. And that's a very circular approach where it's there as a cross-check. The correct approach in my submission would have been to look at how the judge's rate of 17.5 compared with 49 or 50. And the answer to that question in my submission it is obvious. Can I pick up a further point that the judge made, and it's on para 883, and it's a point that I foreshadowed in an outline at the beginning. He was critical of using an industry average selling price. But there's nothing in this at all in my submission. It's a cross-check that should be good across the industry. And moreover, as I pointed out at the outset, if you choose to work in dollar per units with the philosophy that everyone should pay the same in terms of dollars rather than the ad valorem rate, one's necessarily going to have to judge the reasonableness of the stack by reference to an industry average price. And as I've just mentioned, you know that that means that the cheap end of the market, whether it be a cheaper generation or just a cheaper end within a generation, they're in fact going to have to pay a higher percentage than the higher value handsets. If you know that, you're going to have to use that kind of way of looking at it. So, my lords, just standing back, overall, the judge has just failed to utilise the cross-check as a cross-check. And had he done so, it would have been apparent to him that the approach he'd taken in leaving the effect on heavy discounts for past sales in the assessment led to an unrealistically low overall stack, in contrast to what you got if you took the 49 or 50 cents from the LG agreement when properly analysed, otherwise accepting Mr Mayor's unpacking. So, as my Lord Justice Arnold just said, my case is the cross-check actually strongly supports the submissions I've made on ground A, and it was a serious error of the judge not to even look at it as a proper cross-check.
Can I just ask you a very small point about note 46 on your skeleton, on page 21?
Para 46.
No, note 46.
Oh, yes, certainly.
To paragraph 61.
Yeah.
Where it says that you say that 3G rates were bound to come out higher since the judge was using vending royalty and ASPs decline over time. That seems to be a different explanation from the one you've just given us.
No, I think it's the substance of, I didn't mention that the ASPs go down over time as well, but I think it's the substance, particularly of point 1, because the reason it's going to come out higher, let me just try and give you a worked example. If you're using a single price, which has been worked out across both 3G and 4G, it's a bit like what we were talking about yesterday, in that you recognise that the 4G is actually going to have contributed a higher amount than that. So it's a kind of weighted average again. And so then if you use a single price in DPU terms, but then compare it with an average price of a 3G handset, you're going back to comparing it just with a lower price article. So what that means is that, as I said more generally to my lords yesterday, that you're deliberately making the lower price article have a higher proportion that they're paying. It will come out as a higher proportion, a higher percentage. Don't get the impression that I've explained that to my lord to your satisfaction.
Well, the explanation you gave us a moment ago was that the rates for 3G were higher than the rates for 4G and 5G, because 3G are cheaper than 4G products.
Yes. In the sense of the comparison that you do is that you've got an individual royalty for a handset, and what you're doing is saying, what what percentage does that give me as the overall pie? And you're using a price for a 3G handset to work that out.
And
So
the
you
price for a 3G handset is less than a price for a 4G handset, so the royalty stack is going to be a higher proportion of the overall price.
Yes.
That's what you just said to us this morning, and that I understand. But this seems to be a different explanation, which is 3G rates become higher because ASPs decline over time. But you've just said once you get to a later generation, the ASP goes up.
The same, yes. Oh, yes. The same generation ASP goes down as well. So you're going to have two effects.
So, but it is a different explanation. It's not an inconsistent explanation, but it's not the same as the one you gave us this morning.
Well, the point one is the same, I believe, but
Yes.
point two is a further point, which is a similar price comes down, which means it's going to proportionally go up. So
Thank you.
it's in fact two limbs to the same thing, but you're quite right, it's a further point.
Thank you.
Unless there was anything else, I was going to move on to ground D, which is the unwillingness point.
Yeah, now, before we get into the detail of this, can I understand where this is going? So, there is no declaration made by the judge against which you are appealing. Point one, correct?
Correct, but I'm appealing his refusal to not to declare that I was willing.
You say that he should have made a declaration that you were willing. Now, at the moment, that seems to me to give rise to two questions. One, should he have made a finding of fact? Because he didn't. Secondly, even if he should have made a finding of fact, should he have made a declaration? And the question is then, what would be the utility of a declaration in the circumstances in which you now find yourselves?
That doesn't come up. Your Lordship says he didn't make a finding of fact. He did make a finding of fact to the other way.
Exactly, yes. You're right, and I misphrased it. But yes, his finding... So the question, first question is, was his finding of fact rationally insupportable? But secondly, even if it was, what's the utility of a declaration?
Right. Particularly at this point in time, becomes of great significance to my clients because of the problems that we have in enforcing our rights where judges in other courts have said that we're unwilling. It's a real problem for us.
You just used the phrase "in other courts," and I don't understand the relevance of that because this whole court has held that it's not the function of courts in this jurisdiction to tell courts in other jurisdictions what to do applying their own laws.
They're not.
And it's all the more so given that in this case, this court is settling a global license.
Well, that's very true. There is a real practical problem, and it is a different problem from the kind that I think your Lordship thought I was putting to you. You're not telling the courts to do anything at all, but if there is a finding here that we are unwilling as a licensee, that is a very serious matter for us going forward. Actually, not just other courts, but dealing with other licensees. It is a real problem for my clients to have a finding, even though there's not a declaration in an order, that we're an unwilling licensee.
Licensor.
Licensor, I'm always doing that, yes.
But you can't just appeal a finding of fact.
No.
You have to appeal the form of order.
Yeah, and I'm appealing, asking for a declaration that I am a willing licensor. So I understand that, and it's absent from the order. You can appeal a failure to make an order.
If the judge was asked to make an order and it was outside the ambit, well, I mean, the difficulty is this: you're not in a position where the judge made a finding of fact in your favour but refused to incorporate it in a declaration. He made a finding of fact against you, so of course he wasn't going to make a declaration in your favour. So you need to persuade us that even if he had made a finding of fact in your favour, he should have gone on and made a declaration to that effect. discretionary matter.
Yeah, but one of the things that I'm going to, there are two limbs to my submissions, and I'm going to show you that in terms of the discretion, it's absolutely central to the judge's approach that he thought that we were asking for something which was supra-frand. So my submissions on ground A, if you're with me on that, I say there's no way that conclusion that we're not a willing licensor can stand. And I'm going to show you very short and sweet that it was absolutely crucial. And then I was going to elaborate my submissions to my lords about how, in fact...
But that's why I asked the question of what's the utility of the declaration. I mean, as you just, I think, accepted, if you fail on ground A, then the key basis of your attack on this ground disappears anyway. But let's assume you prevail on ground A, in which case you're getting a significant uplift in the lump sum. Let's leave interest questions aside to one moment. And what does he add to have a declaration that you're a willing licensor?
I can see that in that scenario, if I've won on ground A, as would be as well, then the Court of Appeal judgment will trump what he said, and I can understand that. The second limb of my submissions actually relates to if your lordships are against me. And what it adds, the utility, is that it causes my client significant problems in the market with a finding that I'm unwilling, and it's an unjust finding. And I'm going to explain to my lords in due course why that is. And it's basically to do with the position of somebody that has a stance, a position as to what is frand, but is accepting that the court will determine what the implementer is entitled to. And even if what they were asking for was abusive, which is the Optus and Apple scenario, even if they're asking for something which turns out to be abusive, they were accepting that the court would determine it, and they were a willing licensor all along. And that's the submission that I actually want to develop with my lords. And that's the scenario where it really matters.
Well, I think I've articulated my concerns sufficiently for present purposes, so proceed with your ground.
Can I just make good the point that I made that first of all, that actually it was really crucial as to what his determination on frand was. So on the first limb, which is a really short and sweet point, it's paragraph 15 16 of the judgment. You see it right at the beginning. So this is identifying right from the get-go, the judge, it's page 16 of the bundle, in the middle of paragraph 16, he explains he could only assess the allegations on the conduct part of the case against the backdrop of his conclusion as to the appropriate frand terms. And you see in the part of the judgment dealing with this aspect of the case that his view as to what was frand was key. He basically concluded InterDigital was asking for supra-frand rates, so his view is that by doing that we're not a willing licensee. So we go right to the other end of the judgment. For example, in paragraph 928 on page 227. Right at the bottom of the page, we see, for example, him saying there the conclusion he was coming to was driven by his view that what InterDigital was asking for was supra-frand. 934 at the end of the paragraph. Again, he concludes that InterDigital were pressing for rates he had found to lie comfortably outside the frand range. So the conclusion is we're an unwilling licensee. So that's my first short and sweet point, which I understand my Lord's point. If you overturn him on that view, then maybe what does it matter? But his view as to us being an unwilling licensor was firmly predicated on the fact that his view of frand was, for Lenovo, was 17.5 cents per unit. Now the second way that I seek to put my case does require a bit more explanation. And as I just foreshadowed, it's not dependent upon my appeal on ground A. What the conclusion of the judge highlights is a point of some difficulty for a SEP owner if the judge is right. And it highlights a catch-22 situation. How to have a case as to what FRAND is, whilst not risk being held to be an unwilling licensor if it turns out the court disagrees, at least if it disagrees significantly so as to conclude you weren't close enough. And this is actually a bit similar to the issue that my Lord Justice Birss faced in the Unwired Planet case, where you had two parties before you each contending that what they said was FRAND, but crucially one, Unwired Planet, had a case as to what was FRAND, but accepted it would of course be for the court to decide. The big point there was whether it was global or not, but this underlying point is the same, and in that case Huawei's position was contingent. They'd take the licence that the court settled if it was to their liking, and my Lord emphasised the difference in those two positions. And what's underlying that is, we say, a really important point. And my submission is that you can be a willing licensor, but at the same time advance a case as to what you contend is FRAND without fear of the consequence that you're wrong, resulting in a conclusion that you're not a willing licensor. And you do it by making clear that you accept that ultimately an independent tribunal, in this case the court, will resolve the disputes. So take this case specifically, my lords. My client has received a decision from the judge that its FRAND rate is way below what it believes to be FRAND. And it's reasoned in a way we fundamentally disagree with, that you bake in and incorporate the price depressing effect of a non-FRAND effect for discounts on past sales. You don't take it out. And I've stood here all day yesterday explaining to my lords why it's wrong, and that my case is 49 or 50 cents is the right answer. My submission is I'm not an unwilling licensor by advancing those arguments, whatever view my lords take as to them. If I lose, Lenovo gets the licence endorsed by my lords. If I win, Lenovo gets the licence endorsed by my lords. And the position was no different at trial. The scope of the dispute was obviously much more detailed. But as regards that important aspect, it's the same. We were always ready and willing to abide by the court's resolution. And that includes, my lords, the additional argument that we had that Lenovo wasn't entitled to a licence because of the way it behaved. That was a contention advance which the court was to determine. But we never took any stance that that the Lenovo was going to get anything other than what the court determined it was entitled to. In fact, the position at trial was different to what it is today in one way that my lawyers might think relevant, and which makes the position somewhat ironic. And it's this: Lenovo was dragged kicking and screaming to accept that it would take the court-determined licence. In fact, it didn't undertake to take the licence until it saw Mr Justice Mellor's judgment. You will have seen in the judgment that they avoided giving that undertaking to take the licence when they lost on a technical trial before his honour Judge Haycon, on an argument that just evaporated by the time they get to trial. So actually Lenovo was adopting a position akin to Huawei before my lord.
Just on that point, I don't understand it's been disputed, but just so as I've got the chronology clear in my mind. The draft judgment goes out on the 1st of March 2023, and shortly after that there is an undertaking given by Lenovo. Do we find that undertaking in the papers anywhere? Do we know exactly what date it was given?
On my feet I can't tell you, but we will find that for you. My lord's absolutely right, it came in very shortly after the draft judgment went out. I'm afraid to stand here the precise date, or even whether there's a piece of paper in the bundle, I can't tell.
I would be grateful for that information.
Oh, they say it's in the order.
Is it?
So they say.
But the order came later.
Yeah, it recites. It recites.
Okay.
So if you go to page 4 of the bundle, so it's 2 of the order.
Oh right, 6th of March. Yes, that's helpful. Thank you.
I'm grateful to my So, actually at trial, they were adopting a position akin to Huawei before my Lord Justice Birss in Unwide Planet. They were contingent. It was an I'll take it if I like it approach. And InterDigital was adopting the unconditional position mirroring Unwide Planet. Yet, because my clients advanced a contention as to what is frowned, and that it didn't coincide with the judges, and was significantly higher, he's held my clients to be an unwilling licensee.
So,
Now, as we pointed out in our skeleton, the correct analysis is not to focus on an individual act maintaining a position as to what frowned is which is too high, but whether the entity as such ought to be properly considered willing. And that crucially involves looking at InterDigital in the round, and crucially that we were always and did accept that the court would determine the dispute between the parties. And as I said, that wasn't Lenovo's position. And perhaps the most important...
well, I understand why you say that wasn't Lenovo's position, but what about the point that you were asking for an injunction?
We were asking for an injunction in this court.
Yes. Well, not now, but at trial.
That's what you mean, an unconditional injunction, I think.
Yes.
Yeah, that's the point that I mentioned about 2 minutes ago, where I said it's the same, even though I was running an argument that they weren't entitled to a licence now. My contention was that they behaved in that way, but that was always going to be determined by the court. It may be that we turned out to be wrong, and we were. And that's why I made a point of addressing that just a few minutes ago. Our position always was Lenovo is entitled to what the court determines it's entitled to. So we did have an argument that the way in which they behaved and dragged things out had that consequence. But it's the same nature of the point, in that we had a position, but it wasn't us saying, and that means we're not going to give you what the court determines. I understand it's an additional wrinkle, because it's not just what is frowned, but it's the same position we were taking.
So does it come to this? You say you were a willing licensor, because if the court decided that Lenovo were entitled to a license, then you would do what the court said.
Yes, but it's a bit more than that, Michael, because we could never get an injunction other than going to the court. So we were coming
But then that was going to be our question. Is it just not recognising the reality of the situation? If you say, I'm going to sue somebody for something, and I'll comply with what the court decides my and their rights are. In other words, I will do what the court says. In what sense are you willing? You're just a litigant that complies with court orders, aren't you? I mean, I'm not sure. Why does that add anything to saying, well, I've decided to litigate, so I have to take the consequences of my litigation?
Well, because in this context, the only way in which you ever get anything at all is coming to court. And that's the essence of, actually of the finding in Optis, which is that you can still be entitled to an injunction, even if what you were asking for was abusive. You're asking for a rate that's abusive. Let me be absolutely clear, it wasn't determined that it was, but there was an allegation that it might have been, so the whole of that judgment had to be determined on the basis that that might have been made out. And what that decision establishes is that an implementer still has to undertake to take that license, because the licensor is entitled to the injunction, i.e. it's a willing licensor, because it's offering to grant whatever the court determines the implementer is entitled to in due course. I understand.
But could you have realistically gone to court and said, I'm not going to grant a license, or I'm going to choose whether to grant a license depending on what the outcome of the Fran determination is, because if that was your position, you'd never get an injunction.
Exactly, but that was the mirror position. That was Lenovo's position. They're coming to court and they may or may not take it. And that's what I'm trying to emphasise, my lords. The difference between a litigant in my client's position, where they were accepting that they had a position on not only what was Fran, but whether or not Lenovo was still actually entitled to enforce, doesn't mean that we're not a willing licensor.
Can I ask a slightly different question? But it tracks some of the same concerns, but looking at it from a slightly different direction. The bottom line of the judge's analysis is that, subject to one point, which I'll come to in a second, you've just touched on, conduct is irrelevant. Because once the court has determined what is Fran, then the patentee has to accept that. And the only question that remains is whether the implementer will accept it or not. And they have, at that point, a choice. They take what the court has determined, or they're injuncted. And thus, actually, conduct is irrelevant.
It's not quite, my lord, because when you say the patentee has to accept that, they definitely...
Subject to an appeal, obviously.
No, I didn't even mean that. I meant that they have to accept that if they want to press for the injunction to force the other side to take it. But I've seen cases where it's been suggested, or at least talked about cases where it's been suggested that the patent owner won't accept it.
The court can't force you to enter into a license any more than it can force your opponents to enter into a
Well,
license.
indeed, I was misspeaking in that regard. But the choice is you get no relief for infringement.
Exactly. So I'm not trying to...
So I meant as a practical point rather than as a legal point.
But it does matter, my lord, because we were coming to court and saying we will be living by. We weren't in that position of saying, well, we might not. We were coming to court and saying we will live by it, and they will get whatever Lenovo, the court determines Lenovo is entitled to. So, and that's the crucial thing that makes us a willing licensor in my submission. We weren't trying to play the hokey-cokey and be half in and half out and decide which way it was afterwards. We were fundamentally in a different position to Lenovo. The judge was going to determine the dispute, and they were going to get whatever, in his judgment, subject to an appeal, he determined.
Well, can I just test that? I mean, you may say my question is beside the point, but did you ever give an undertaking to grant a license on the terms that the court determined to be frank?
I think we made it pretty clear again and again that those whispering round me suggest that it might even have been in the particulars of the claim at the beginning. But we made it clear, and I will find those around me will find the best reference to show you that. There was never any suggestion that we wouldn't, and I'm sure we made it clear.
Can I ask a stupid question? You say you agreed with my lord that you weren't actually under an obligation to enter into a license. But isn't that ultimately a matter of French law, and whether the stipulation pour écrit is enforceable?
Your Lordship's touched on a whole massive topic, you're quite right. There would be, potentially there's an issue as to whether it's a specifically performable issue. But some judges have looked at it in the way that my Lord Justice Birss indicated to me that they can't actually be forced. The only way to deal with it is to withhold the injunction. I think that might even be part of my Lord Justice Arnold's analysis in Optis. I might be wrong, but I've got a recollection just standing here on my feet that I think you've said something like that in one of these cases. But not in the face of an argument that is specifically performable. So there is, my Lord's absolutely right, there is a potential for an argument that it's a contract which not only can be enforced to make you offer it in order to get the injunction, but actually a contract that can an order can be made to make you comply with the contract. But it's never been decided, and I think there are some dicta that suggest to the contrary.
Thank you.
This is a what I might have in mind is the Court of Appeal in Unwide Planet. Mr Chatsworth's just given me paragraph 27 that suggests that neither Unwide Planet or Huawei could be compelled to enter the contract against its will. But that, again, with no argument about whether or not, in fact, under French law, that was specifically enforceable. Now, I think I've actually galloped ahead of my submissions and made them without actually turning up Optis. I can show you Optis, both Mr Justice Mead and my Lord, but
Isn't it sufficient to
Yeah.
look at what this court said? Briefly.
I suppose it is. It's my Lord. It's much more brief though. And the reason I was going to go to the...
All right, well, I'm sorry. I shouldn't have interrupted you.
The reason I'm going to go to Mr Justice Mead is because he pins it back to the Supreme Court in paragraph
All right,
164.
So, let's do
So
that.
we need bundle, authorities bundle 3, tab 29. And the key passage is para 326 on page 908. And you see at the start of this paragraph, the judge is considering the possibility of a subsequent finding of abuse. And the abuse allegation centred on two related aspects: seeking excessive royalties, and the second aspect was, you see further down in the paragraph, rushing Apple into a licence without adequate knowledge of Optis's portfolio or the basis of its requests. And the judge rejected these as making any difference as to whether Optis was entitled to an injunction. Now, as to the point on seeking excessive royalties, the judge relied upon that paragraph in the Supreme Court of Unwide Planet, the one that I've already said there's a bit of a tension between what the judge was saying and that. And it's set out earlier at 164, but I've shown you already, it's that eBay quote where they say that you can't use the threat of an injunction to get super fan because you have to have offered something that the court is satisfied are fair and reasonable and non-discriminatory to get the injunction. So the point is obviously that even before FRAND has been determined, one can make it clear you accept the court will determine the dispute, and therefore the injunction can't be used as a threat to get more. And if we continue looking at para 326 of the judgment, we see it's emphasised in the middle of that paragraph, after mentioning 164 of the Supreme Court, that the court is going to set FRAN rates and Optis is going to have to respect them. Optis had a case as to what it should be, but recognised it had to live with them. And you see that expressly pointed out in para 3291 at the bottom. Optis accepted it must give a licence and they will obey the court's decision as to the FRAN terms. And the second point about not having adequate knowledge of the basis of Optis' request was also rejected by the judge in the second part of 326. The parties were too far apart to have settled, and in any event, Apple knew Optis' case from the pleading. Now, we can see my Lord on the same case in tab 32, but it is much briefer. If we go to para 94 at 958, we see my Lord 4 lines from the foot of the page referring to the fact Optis accepted that they must grant a licence and have pleaded their case and will abide by the court decision as to what terms are FRAND. And then my Lord says this: all Apple need to do to obtain a licence upon FRAND terms is to accept the court's determination. The only obstacle Apple faces, their own unwillingness to commit. And over the page we see my Lord records what Apple's reason for being unwilling was, because they wanted to protect themselves against the risk the Fran terms determined by the court were commercial or unviable. Well, that's just a nice way of putting that Apple saying they wanted to ensure that if they didn't like the licence eventually settled, because in their view it wasn't Fran, even though the court said it was, they weren't going to take it. And as I said, that was actually the position here. Lenovo, like Apple, simply had to agree that it would abide by the court's determination, but they wouldn't. And I suspect if my friend actually tells you why they wouldn't, I doubt whether he will, but if he does, it will be like Apple. It wanted to reserve to itself the decision as to whether the court determined licence was Fran and acceptable to it. But the upshot, my lords, is that even where there are allegations of demands so high that they're abusive, where the dispute is being submitted to the court for determination, which the SEP owner will abide by, it is a willing licensor. And in that case, you see it was entitled to injunctive relief when a patent is found valid and infringed. And it can only be because it's a willing licensor at that stage. And the fact that it had a position as to what is Fran, even one that turns out to be asking for abusively high rates, doesn't change that. And we say we're in no different position here. And even if you're against me on my submissions as to ground A, as to what the correct Fran rate is, my client was a willing licensor. So that's the point on unwillingness, even if you're against me. Is there anything else that I can help my lords with?
No, thank you very much.
I did have actually, sorry,
Not at all.
a couple of questions. One, just arising out of what you said, you've explained to us why you say that you were a willing licensor. Do you not also have to explain to us why, as a matter of discretion, we should make a declaration to that effect to put into the order?
That's the issue of the damage that we are suffering, particularly in the light of the way it's gone thus far. And we explain what the problems are in our skeleton.
Thank you. The other question I had, actually it's a couple of questions, but going back to Grand A and what you said yesterday. First, you showed us, by reference to tabs 18, 22, 23 and 24 of Supplementary Bundle B, how Mr Mayor had split the total consideration between past and future, and then used that past-future split to apply different adjustments to the past and the future to produce an adjusted blended rate. He didn't take the blended rate and adjust it, he took the individual splits and adjusted it.
And then blended it at the end.
And blended it at the end. But if he hadn't used the split which he took from your client's accounts, there would have been if he'd simply attributed the total consideration equally across the past units and the future units, it would have attributed more to the past units, and it would have therefore, where the adjustment was higher, would have produced a lower rate for the past units, and hence a lower blended rate overall. So my question was, isn't that split something that was actually something beneficial to your client? Is that right? Have I misunderstood that?
Oh, if your point is simply the split gives a higher future rate and a lower pass rate, absolutely. It's beneficial over what he's then done, but that's the whole point of my opinion.
But not just it gives a higher future rate and a lower past rate, but by putting more of the value into the future where the economic adjustment is less, it gives a higher blended rate.
Oh, let me be absolutely clear. If what my lord has done is look at the particular adjustments that were different in the past and the future, that may or may not be true for LG. I haven't actually even turned my mind to that. It's just more accurate in his view. So there may have been other agreements where it was different. So
I see.
Your lordship may be right. I don't know, but the point that I was trying to get across yesterday is not that those particular adjustments were good or bad for me. They were just accurate for the past and the future for that agreement, and they're different, which means that ultimately the answer that you get at the end is dependent upon the split of consideration. And across each of the agreements, one would expect that some might go one way and some might go the other in terms of whether the
I see. Yes.
So I'm not at all trying to make a point about whatever the particular number was for past compared to future on an adjustment. I was trying to make a point that he thought it was necessary, or at least better accuracy, to split past and future, then do the separate adjustments and then blend them up. And it's simply that he thought it was more accurate, and it was a different approach to it if he'd gone from the blended rate on the unadjusted stage and then adjusted to another blended rate.
Well, that leads on to my next and I hope last question, which is this. The actual, when all we've got in terms of the factors to the payment is we looked at the license agreement, the LG license agreement. We have a single sum, which as a matter of contract is all attributed to the future license fee. None of that, it's not split in the contract, it's not split into past and future, but there's also a release of the past. So that as a matter of contract, the parties have agreed that the entirety of the consideration, I'm not going to mention figures, is attributable to future. But we know that everybody accepts that some of it has to be attributed to the past.
I don't think it's quite right to say, as my lord just did, that because it doesn't set out the detail of what might have been contributed by the past, they have agreed that it's all attributed to the future. What they've agreed is some money to be paid, which can only ever be paid now or in the future. You can't pay in the past. So they've agreed, in fact, in that deal, not everything paid on day one. There was some
yes, it's staggered into the future, but that's just a question of timing of payment.
Indeed, but so
I thought when we looked at the agreement, and I don't remember where it is.
we had it yesterday. Something.
Chapter 9, was it?
Yes.
What I was thinking of was clause 2.1, which contains the license grant.
Yeah.
In consideration for payment of a license fee instalments, then there's a grant of a license. And then when you come to the release of the past, that's not said to be in consideration of the payment. In other words, it's just...
I understand what your lordship's putting
Yes.
to me, but I think if you look at 3.1, you'll see something to the contrary. In consideration for the licence and the release granted period.
I see.
And I think even if I couldn't point to 3.1, the argument is, in substance, everyone knows that the sum's been calculated for the whole deal. And then the question is,
How much of it is future and how much of it is past? Now, the question I was going to put to you was this, was you showed us how your client accounted for it, and you showed us how LG said that they had attributed value to the two parts. But even if the parties had agreed how much is attributable to the past and how much is attributable to the future, a split of consideration for two things like that isn't binding on other people. I take a completely different case. If someone buys a house and contents, it doesn't matter how the vendor and purchaser divide up the total consideration between house and contents. The revenue is entitled to say, actually, we think a more accurate economic apportionment is X, and we're going to tax you to stamp duty on that basis. Why is that not the same here? Why can't somebody else, in this case, the respondent, say, well, even if the parties to the LG agreement had apportioned it, X to past and Y to future, I'm not bound by that. I'm entitled to look through what they've said at the true economic underlying value of what is actually going on.
The reason in my submission that that's not an answer to my case is because of the nature of the exercise that you're carrying out. And that's why it took some time to explain what you're doing. What you're doing is trying to work out what a reasonable winning license or a licensee would value the individual units at by looking at what they came to as an overall agreement, but understanding that they're going to have been negotiating on particular basis. So that's why you look at the number of units that you anticipate that they've rejected at all, is because you're assuming that they have in their mind several moving parts, but broadly an amount for a future sale, an amount for a past sale, and then those number of units that give an overall sum. So what you're actually looking at, the aim of the game in the exercise is actually to look at real life negotiations and try and infer what the individual value for a unit in the future and the past was from it. And that's why it's legitimate to do what I've done.
Thank you, that's very helpful.
My apologies to my lord for cutting him off. Does my lord on the left have any questions?
Apparently I've said everything that everyone around me wants.
Yes, Mr. Arnold.
My lords, we propose, subject to your lordships, to address the appeal and cross-appeal in the following way. First, I'll make some introductory points, which we'll be inviting your lordships to bear in mind for all of the aspects of the case, including drawing attention to some key parts of the judgment to which you haven't been referred. This is, as my lords will know, the first substantive grant determination to reach this court, and is accordingly of quite wide interest. And it may be helpful for all members of the court to have some of the context in mind which was before the judge. The cases on these kinds of appeals are referred to appeals identifying an island in a sea, where the Court of Appeal only is looking at a particular island. And I'll just invite you to look at a few parts of the sea, again, which are the background against which the judge made his determinations. Then Mr. Segan will address grounds A and B in greater detail and show you why the points that have been made by IDC on LG and the other licenses are completely unjustified. Our overall submission is that the judge was not only entitled to reach the view that he did as to the valuation based on that license, taking it as the primary comparable, but that he was right to do so, and there were no errors in his analysis. It is realistic, and it doesn't build in any undue depression, which is the central part of my learned friend's case. Third, I'll address grounds C and D, the so-called top-down cross-check, and the declaration point, and will then open the two issues on our cross-appeal. Those points on the cross-appeal, as my lords will have appreciated, are novel, and as the judge recognised, represented a departure in approach as to how licenses of this kind have been addressed by those in the industry, and indeed how these issues have been addressed in the courts. And we will be submitting, in summary, that on these points the judge went out on something of a limb in a way that the court should not endorse for a range of reasons, and I'll develop that in detail later on. So may I turn to the appeal and just emphasise at the outset really how remarkable this appeal is, that the 17.5% rate determined by the judge was not only in line with the LG agreement, on which he was right to rely, but was consistent with all of the other evidence including the other major undertaking licenses to which he referred, and which he used essentially to identify the LG license as the primary comparator. But the judge analysed a number of those agreements, and I'll show you just the analysis of one of them, just to give you an example of the kind of material that was before the judge, and which, in some senses, was an internal cross-check, which were agreed in circumstances in which the points that IDC makes in respect of the LG license simply couldn't arise. Indeed, in one case, in the case of Samsung, agreed under extreme pressure in circumstances where there was no issue of past sales, so the issue of past compensation or depression of past compensation couldn't possibly arise, as the judge held. Now, not only was that agreement consistent with the findings of the judge, the approach that the judge took ultimately to the LG agreement in identifying it as an appropriate comparator was completely consistent with that and indeed the other basket. And having analysed the basket of realistic potential comparables, he identified a lead comparable in accordance with actually all really of the case law relating to valuation of this kind, where one seeks to identify in some senses a closest comparable. It's an approach that my Lord Justice Birss took in Unwired Planet. It's been taken in many other cases in this context. It reflected most closely the position of Lenovo, and he scaled it and applied it in an entirely appropriate way.
Just can I ask you a little question at this stage? You observed when sort of outlining this landscape of your submissions that the points raised on your cross appeal are novel. And I understand why you say that. Focusing specifically on the limitation question, my understanding at the moment, and it's consistent with what you've just said, is that the judge's decision is the first time ever in which it has been held that limitation would not be a factor in willing licensor and willing licensee.
My Lord, we believe that to be the case. Indeed, our submission, which I'll come to in greater detail, goes further than that, because if one just to answer, my Lord...
Just before you go on.
Yes.
Can I just therefore ask this question? Let's assume that that is indeed the case. Namely, the judge has broken new ground. Let us also assume that this court comes to the conclusion, ultimately, that he was right about that. Now, upon those two vital assumptions, what guidance can one get from past decisions or agreements which were not predicated upon that?
Well, one can get a considerable degree of guidance, in particular from past agreements, where the issue of past sales didn't arise at all. I'm going to come and show my Lord one of those. Because in those, the issue of limitation simply doesn't arise. There's no question of past sales.
Thank you.
And that applies to more than one of the agreements in this case, as Mr. Segan will show you. But our point in relation to that is...
These are the ones that weren't chosen as the good comparable.
Beg your Lord?
These other agreements are ones that were chosen not as a good comparable.
No, but I'll show my Lord the reasons why that was the case, and why actually, if one looks at what the judge said about those, they reinforce the point that the LG agreement was a good comparable. They're exactly the reasons that the judge found. And I'll come on to that and spend a little bit of time on that, because there's an important section of the judgment which reflects some of the broader points in this area, which my Lords really do need to bear in mind in the context of this case. May I just step back just a little bit, just to outline a few general points. In some senses, they are too obvious to say, but not everyone has had to look at these licenses in great detail. Obviously, the subject matter of these licenses is SEPs, but as all of my Lords will know, SEPs are of very different kinds, and indeed, one of the characteristics of this industry is that many patents are put forward as potentially essential to a standard, would turn out not ultimately to be essential to a standard. And of course, my Lords will also appreciate, and it's a point that was mentioned by the judge and is in some senses self-evident, that there are significant parts of the standard that are not subject to patent protection at all. They are literally standards. It's like a railway gauge. Everyone agrees to have a particular protocol for transmission where there's no invention involved. It's simply an agreement. And all of these issues give rise to difficulties of valuation. And I'll come on to how...
Sorry, excuse my ignorance. Is there any downside to a patentee declaring his patent as essential?
Yes. So there's a plus and a minus. The plus is if you get your patent declared as essential and it is found, what is held to be essential, then you can essentially claim under the... It's like essentially making it the subject of a license of right. That's the effect of it. And so to that extent, if you declare it to be essential and you have a valuation system which depends in some way on numbers of patents declared to be essential in whatever way, then by saying, oh, my patent is essential, you are essentially raising your portfolio value. And you may be raising it not just in absolute terms, but you may be raising it in relative terms, relative to someone else who may adopt, let's say, a more conservative declaration policy with respect to patents. Because one of the points that I was going to make, I'll make it now to answer my lord, is both SEPs are different and SEP owners are different. Their practices are different. Some adopt what might be called quite an aggressive approach to patenting, where you've got, for example, multiple patents covering essentially the same invention. That's not just a theoretical point here. We know, on the evidence of this case, because it was in the evaluation reports, that InterDigital's portfolio, what was said about one of the valuations in relation to the 3G, was that although they had 50 to 60 patents, there are only 5 to 6 inventions there, because InterDigital's approach has been to essentially inflate by numbers the number of patents they had. If one adopts a more conservative approach to patenting, then one might only have 6 patents in one's portfolio. But as my lord will of course appreciate, this is an area where what might be called gaming is not entirely unknown. And it's not only a question of gaming, but...
In any event, 6 strong patents might be worth more than 60 weak ones, even if the 60 weak ones are all separate inventions.
It may well be. It may well be. I mean, the evidence on this case was actually to the contrary on that as well, for the reasons that we've identified.
We also shouldn't ignore the fact that one of the reasons for over-declaration is the concern that if you under-declare your SEPs, you will be held to be abusing competition law.
My lord, I was coming on to that as well, which is this. So that's the plus. I've looked at the plus side of
well, I can see why people
declaration.
Might be tempted to over-declare.
Absolutely, and the plus side, as my Lord Justice Arnold has identified, has a positive aspect, and it has what might be called an insurance aspect, that you don't want to be accused of wrongly under-declaring. But then there is a negative, which is that if you declare something that is essential that isn't in fact essential, that is, for example, I can get into all sorts of complications, optional, or what's sometimes called an implementation patent, you may thereby be depriving yourself of the ability to get an injunction and have those in the industry essentially over a barrel who use that way of implementing the standard, because that patent would then not be subject to the requirement that it is has FRAND licenses granted in relation to it. So sometimes implementation patents can be more effective remedies precisely because they're not subject to the moderating stricture of the ETSI undertaking. Now, there are all sorts of sub-points on that, as those who've been involved in this will know. And even if I lay out the terrain in that way, my lord will be able to see that, if I follow my lord's example of house valuations and so forth in relation to stamp duty, that it is an area open to what might be called creativity. And I don't use that in a pejorative sense. I use it in a sense that there isn't necessarily an absolute standard in relation to some of these matters. So that's the background against which this arises, and why sometimes valuation is hard. But one of the other reasons, of course, is that just in relation to incentives in SEPs, there can be incentives to try and get a patent granted that covers the standard, because you can then rely on it to get injunctions subject to a frowned remedy. And in some of the cases, what people try to do is they apply for a patent for X. The standard then develops into Y, and they say, well, can I actually tweak my patent so that it then looks as though it covers Y? Now, the problem with that, of course, is that if you do that, and there's some patents in this field which have been held invalid on that basis, you probably will add matter to the patent, and therefore the patent becomes invalid. But if one is not looking at validity at all, one's only looking at essentiality, the patent looks, oh my goodness, that reads onto the standard, even though in fact it illegitimately reads onto the standard, but only can be discovered to illegitimately read onto the standard by often quite complex and uncertain litigation in various countries. And my lords will, of course, also appreciate that that kind of tactic and approach it not only results in what might be called unjust enrichment for the patentee, it also potentially deprives someone else who may have come up with the invention of their own rights, because what essentially you're doing is then trying to claim what someone else has done by way of development of the standards as your own on the basis of something that you haven't contributed. And my lords, in this case, haven't had to look at the many thousands, I think probably hundreds of thousands of pages of the standards, but they are not always written in the most pellucid language. And so that gives rise to immense disputes, and lack of pellucidity and transparency is one of the issues that absolutely bedevils this whole area, and can be extremely profitable, because as we will see, if you can raise the risk on a defendant that they might be caught by a patent which is not subject to a reliably moderated frowned undertaking in a major jurisdiction, that is an incredibly severe negotiating lever on some of the major manufacturers in this field. And I'll show my lord how that actually has affected the position, and in response to one of my learned friends' submissions. So that's a somewhat longer answer to my learned friend's question, but it doesn't have a very brief answer, because it's a complicated terrain.
Thank you.
So that's actually covers some of the ground that I wanted to cover in any event, and what it gives my lord is a sense of quite how difficult the issue of valuation is. I don't know whether my lord, Lord Justice Nugee, has been involved in actually looking at some of these substantive telecoms patents in your capacity as a judge, but they are often quite complicated, and there is a joke in the industry, which is not only a joke, which is that one non-infringed and invalid patent is just one non-infringed and invalid patent, but 10 non-infringed and invalid patents is a portfolio. And part of the reason for that joke is because assume every such non-infringed and invalid patent has a 10% chance of being upheld. Well, one can do the statistics and think, this is putting some risk in relation to those who are potentially using the standards. So, as we put out in our, say in our skeleton, this is an issue that is currently being looked at by the European Commission, their proposals for draft legislation to address some of these issues in relation to transparency, which have come in for some criticism in some quarters. But there's no question but that the issue of valuation is a difficult one in this area, and is made harder by the fact that it's very hard in a portfolio which may consist of 100 or more patents to do a precise valuation of each. But that is important for this case, because it is one of the reasons why comparable agreements, which are based, as the evidence showed, on major manufacturers having done quite detailed analysis before they enter into the relevant agreement, both technically and commercially, are so much more important and so much more valuable than third-party analyses, which may only look, for example, at the question of essentiality and may not look at the question of validity at all in relation to a portfolio. And why, in a case of this kind, it is right in principle to, in a sense, make use of the distilled reflection of those who've entered into agreements, including, in some cases, the patentee, because the patentee also appreciates that their portfolio may not be as strong as they'd like to think it is, which are then reflected in the relevant agreements. But does that give my lord enough background terrain? I'm sure that in the discussions that my lords have, if I've said something that doesn't sound right, that will be corrected. But in my submission, that is the landscape that we're dealing with. So, and just finally on this point, just to reinforce the issue on what might be called patent PR with this area, that there was evidence that the judge had that when InterDigital started its litigation program, which it did, then led to licenses, they took a very aggressive stance of suing in the ITC in the United States. And the thing about the ITC in the United States is it's not a court that's subject to these strictures on eBay, which you may be familiar with, where there are limits on injunctions being granted. If your patent is valid and infringed in the ITC, you can exclude what might be called foreign products from coming in. It's a protection for the American market. It's an incredibly aggressive tactic. They took that tactic, or they took that action tactic, as pejorative perhaps, against Samsung, when Samsung was not prepared to renew a deal on the terms that InterDigital was happy with. They chose 15 of their patents, InterDigital saying, these are my best, super best. And they were found to be invalid or not infringed. So you have a situation where quite often patentees come along and say, we've got a brilliant portfolio, actually put them to the test. And it turns out that actually the portfolio is full of duds. And this was material that was before the judge, and we refer to it in paragraph 100 of our skeleton argument and the various other tests that were made of this portfolio. So that segues to the next general point that has been the subject of some debate before my lords, which is the issue of the power in the hands of SEP owners. Now, my learned friend made a submission which I did find quite surprising on the basis of Unwired Planet, that there wasn't really any problem in this area because the English court was able to act, to do essentially what the Copyright Tribunal does in this field, which is to say, look, if there's a dispute about a license, I'm obviously not going to shut down the BBC because PRS comes along and says we want to be paid more for music. Or at least I'm not going to do so before it has been determined whether the license in question is in fact a fair, reasonable and non-discriminatory license. In fact, the terms are not exactly the same in the Copyright Act, but they're not that different from the FRAND jurisdiction. No one would think that was appropriate, and it's obviously not done. Indeed, there are specific provisions in the Copyright Act that say you can extend a license if it's not unreasonable for it to remain in force. And it is true that as a result of the development of the Unwired Planet FRAND jurisdiction in this country, essentially what has been created is a copyright tribunal-like jurisdiction here. And that has two important elements. One is that an injunction will be granted if a person does not say that they're, as it were, subject to the jurisdiction of the tribunal and agrees to take the license which has been so settled, but equally that an injunction won't be granted until that has actually happened, until a determination has taken place. And a determination, which I mean a full determination with proper evidence, deciding what are in fact the fair, reasonable terms, not just saying, oh, well, that looks as though this is a kind of reasonable, might be a reasonable offer that the patentee has made. It's a determination of what are the reasonable terms. So it is the valuation of the relevant rights. And obviously, if you don't pay in relation to the valuation of the relevant rights, not some asserted valuation of the relevant rights, then you may be subject to an injunction. That is the value of the jurisdiction which has been created in a non-statutory way by the use of what might be called a qualified or a conditional injunction. But that is not true everywhere else. So take the ITC for an example. The ITC doesn't do full substantive brand determinations. So you can get an exclusion order in the United States without there having been a full copyright tribunal evaluation, tribunal-like evaluation, of whether the demands of a undertaking are in fact reasonable. We referred in our skeleton argument to some recent litigation before the Chancery Division in a case between Ericsson and Lenovo, where an SEP owner was using the power of an injunction, in that case in Brazil, to try and shut down, in that case, Lenovo's business as well in Brazil, while a determination was going on of what the relevant valuation should be. And my lords have already referred to this case and the injunction that was sought in this case, because I venture to suggest that the Supreme Court, in saying, in broad terms, look, we're fine in this jurisdiction, didn't have in mind a situation where an SEP owner who themselves had consistently over a period of 10 years failed to provide an offer that was even in a FRAND range, had run a discriminatory, completely non-transparent licensing program to the disadvantage of many in the industry, and had made, I think, the form of order hearing, IDC was sitting on $1 billion in cash as a result of its licensing activities. We're not talking about widows and orphans here. That such an undertaking should come before the English court and say that Lenovo, who had been trying to get information out of them and have a basis for making adequate offers for a period of years, and were quite regularly provided with either incorrect or incomplete information relating to the licensing program, that IDC would say that such an undertaking was not entitled to a FRAND license at all. And this wasn't just a side wind of IDC's case. This was its primary case at trial. And if I can just show my lords very briefly the opening skeleton, just two passages in that. It's in Supplemental Bundle B. And it's at tab 2, page 14. Paragraph 25. At this FRAND trial, the court will determine 4 things. First, whether Lenovo remains entitled to enforce InterDigital's ETSI FRAND undertaking so as to avoid injunctive relief. And this is not conditional injunctive relief. This is final and absolute injunctive relief, putting IDC into a position where essentially they would have Lenovo completely over a barrel with no recourse to any kind of reasonable FRAND undertaking. Paragraph 26. As to the first of these issues, InterDigital advances the case 3 ways. And the first allegation is a fact-sensitive allegation. They describe it in a rather, let us say, euphemistic way, that Lenovo has not conducted itself such as to be entitled to enforce the ETSI obligation. It is not within the class of beneficiaries because of its recalcitrant conduct. That was then reinforced on page 41, at paragraph 90, InterDigital seeks an unqualified injunction on the basis that Lenovo is not a beneficiary of Clause 6.1 of the ETSI undertaking. Pleaded case relies on Lenovo's general conduct in negotiations. Well, once that issue had been looked at by the court concluded that so far from Lenovo being at fault, it was IDC who was at fault. And it is of some significance that the findings of the judge, which my lords have seen in relation to IDC as an unwilling licensee, are not appealed, because the underlying facts of that are, once one actually exposes the truth of what IDC was up to in this case, they are absolutely irresistible. And you can see that. We put in the material in Annex 5 of our closing skeleton. You can see that the allegation is simply unjustified. But the point for present purposes, I just want to tie it back to the appeal, is that patentees, even SEP owners, who have made an unqualified ETSI declaration, will try every tactic, including turning the facts exactly the opposite way round, so accusing others of unjustified conduct, which is in fact their own unjustified conduct, to avoid being subject to the FRAND licensing jurisdiction. And that means that the risk that is imposed on those in the industry and the power that injunctive relief gives to undertakings means that the argument that they have been in some sense shortchanged in history by being unable to exercise this power is actually wrong. And I will show my lords exactly why that is by reference to the Samsung situation, because it is illustrative of the actual impact of the power and why it has the effect of actually enabling those in IDC's position to obtain fair and possibly even excessive compensation for their patent portfolios. I can take that up in the judgment at the core bundle at paragraph 626. Where the judge is in the course of analysing the Lenovo 7. And I will just take this as an example of the kind of way in which negotiations proceed, because as the judge held, a number of them were preceded by litigation, and so people, exercising real force. So at 626, the judge records that Mr. Grew said that Samsung was one of InterDigital's longest licensees, having taken at least 3 licenses over the years, paying over $1 billion in fees. Previous license then expired. Then there were technical discussions. Parties began discussing financial terms. Mr. Grew described Samsung as having balked at the rates and fees which InterDigital was negotiating toward. And the judge says this, in an acid but justified aside. Of course, if InterDigital had put forward its program rates, this reaction cannot have been a surprise. However, I rather doubt that InterDigital would have dared to put forward its program rates. Now, these were program rates that it was seeking to obtain from others in the industry, including smaller parties in the industry. Whatever the actual position, Mr. Grew says, as a result, InterDigital included Samsung in its US ITC action as from January 2nd, 2013. And by the time this particular license was agreed, InterDigital trial had taken place, and the decision was just around the corner. And Mr. Grew indicated, and this is important for the issue on the suggestion that this was an agreement that could have been affected by any past issue. Mr. Grew indicated that the purpose of the effective date was to ensure that Samsung were continuously under license. The past sales were treated the same as the current and future sales. So although Mr. Meyer estimated there were sales of that number of units, and unlicensed at the time, the parties treated them as licensed sales. I believe this is why Mr. Meyer considered this PLA did not involve any past sales, only future sales. So here we've got an agreement which doesn't suffer from any of the vices that are alleged to affect this position. And I'm not going to spend time with my lords on the whole of the analysis. My lords can read that for yourselves, and I would invite your attention to that from 628 to 634. But perhaps if we go over to page 165 in paragraph 634, little Roman 4 E, to similar effect, Mr. Grew explained that at the time of the deal, InterDigital considered there to be a reasonable possibility that they would succeed in obtaining the exclusion of all of Samsung's standard compliant products from the USA. And then there were the ITC proceedings that are referred to. There's evidence from Mr. Merritt and Mr. Grew. These were two very senior licensing executives in InterDigital. Mr. Merritt at the time was the chief executive of InterDigital, and Mr. Grew was a senior licensing person. Plus the fact that Samsung agreed the PLA just 13 days before the ITC decision was issued, suggests to me that the ITC proceedings were seen by Samsung as a significant threat.
And yet the judge's conclusion was that Samsung was a little low.
Slightly. Slightly.
But low rather than high.
Oh, indeed, and I accept that this is a situation where, as has been said in some of the copyright tribunal cases, you've got, in some senses, two big beasts, or one big beast and another beast with very serious weapons. But coming on to my lord's point in relation to that, if you look at the judge's analysis over the next page, paragraph 642 to 645, what are the reasons and why only slightly? Nothing to do with hold out or hold up or anything along those lines. Reverting to my assessment, he specifically finds Mr. Bazant's points unimpressive, seems to be trying a little too hard to find reasons to suggest that InterDigital may have agreed to a lower rate. There are, however, indications that the Samsung rate was slightly low, and then he assesses the situation, skipping over that detail with the confidential information. Undoubtedly, each side faced pressure to reach a deal. In the ITC proceeding, Samsung faced the prospect of having their products excluded from the US market. However, it was clearly very desirable for InterDigital to be able to conclude, announce that it had agreed a long-term license with the market leader, albeit such a substantial deal came with a price. Overall, I incline to the view that the rates derived from Samsung's 2014 were somewhat depressed by the factors I have just discussed. Now, those are factors essentially saying, well, actually, because we want to do it, because we're a licensing company, we want to get a reference deal, essentially, at an early stage. We might do something that's slightly on the lower side. But the idea that this was remote from the fundamental value is not only completely contrary to the findings of the judge, it would be quite wrong in circumstances where here you've got two powerful negotiating parties, including a negotiating party who is, in the case of Samsung, continuing a licensing agreement where products had been under license. So this is someone who can't in any way be described as, in notional terms, in dereliction of licensing duty. So in our respectful submission, it is that kind of conduct which shows that where you have a basket of agreements which are agreed against the background of actual or threatened litigation, which reflect a reasonable degree of evaluation by the relevant undertakings of the actual value of the portfolio, not just the numbers in the portfolio. Those are reasonable reference standards by reference to which, if one's looking at matters on a per unit basis, one can say, well, actually that's something that needs to be taken very seriously into account. My learned friends would say, indeed they have to say for the purposes of this appeal, that the judge's findings in relation to that aspect were completely wrong. It was not that they were slightly low. It was that they were completely unjustified, because the per unit rate that he seeks to extract out of my clients bears no relationship, reasonable relationship, to that finding. So my learned friend faces the difficulty of inviting this court to overturn that evaluative finding on the basis of the judge's analysis, in order for him even to get within range. But the point is reflected in a more general point, which is really contrary to my learned friend's overall point. And it is perhaps best expressed in paragraph 729 of the judgment. Just invite my Lord's attention to that. It's at page 182 of the bundle. Judge says, and it's interesting that my learned friend drew my Lord's attention to paragraph 728. Your Lordships will recall that, where the judge says that InterDigital have been affected by a degree of hold-up, but the issues are whether the impact is reflected in the royalty rates in these PLAs, and if so, to what extent. And he identifies the points in relation to the ability to obtain a global license and the perceived influence of national limitation periods. But then, what happens in 729, to which I don't think you were referred? The judge says, against that, InterDigital are a large licensing organisation with ample funds to spend on litigation. In one sense, InterDigital and other ACP licenses have received something of a windfall from the very large increase in cellular device volumes over the years. In short, it is more than able to look after itself. It is not shy of litigation, and most of the time, it is able to choose the forum in which it brings the claim. Furthermore, InterDigital has developed ways to cope with the two obstacles. So the judge is identifying the obstacles, but he's also identifying the fact that InterDigital specifically has identified ways of coping with them. And it has led to considerable distortion, particularly in future rates, which can be derived from their PLAs. So what the judge is saying is that one method of coping with what might be called the past is to inflate the future. That is the distortion that the judge was referring to. So my learned friend, when he refers to paragraph 457 and 728, has to face the fact that, again, the judge finds on the basis of evidence, and indeed evidence one can see reflected in the agreements and the way that to some extent these splits are done, that there is, as it were, significant coping.
How does inflating the future compensate for unfair or unfrowned discounting of the past?
Well, in an agreement, what you would say is, well, okay, I'm going to charge you more notionally in relation to the products that are the subject of the license, in the sense that are the ones that are the... If one envisages these licenses as composed of two elements,
yes,
one a prospective and one a retrospective part, then in terms of the overall evaluation, you'd say, well, I'm going to charge you more for the future to compensate for the fact that the past in question is notionally lower.
Yes, but my point is that if the reason for the past being lower is that it's not fair, then it's not. You're not compensating for it by inflating the
No,
future.
that depends on the extent to which you compensate. Because if you overcompensate, then that's the whole point.
That's why at the moment I don't see it. I mean, of course, it's a truism that if in the example we're talking about, if the past goes down, the future goes up. If you're trying to stay constant, I understand that. What I don't understand is why it's a compensation.
Well,
for an unfairness.
If the past...
If the past discount is unfair,
yes,
then the inflation of the future is fair, not unfair.
Oh, I see what you mean. Well, you may be right. You may be right to that extent, and I understand where my lord is coming from. It may be right in the sense to attribute more to the future in that sense. But if you're then looking at the whole valuation of an agreement, then you're dealing with an agreement which has a notionally higher element for the future and a notionally lower element for the past, but it's fair overall. It is fair overall.
Right.
But it's only fair if you look at both elements,
Yeah.
history, and that is exactly what was done in this agreement, doing the comparables. the whole purpose of Mr. Mellor's exercise was to say, well, you need to look at all of the compensation in order to get a fair compensation. So that's the core point. But my point on this is that this is something that is, in a sense, addressed.
I'm sorry to be tedious about it. What I don't understand is why the increase of the future in the example we're giving is a distortion. It's not a distortion, because if you didn't increase the future, but you had lost in the past, then the blending of the unfair low future with the unfairly low past would give you a lower answer. It's not a distortion.
I understand what your lordship is putting on that, but equally what that doesn't address is the fact that if you're looking at an agreement over the whole of the period, you need to look at both elements. What you can't say is, oh well, I'm focusing on the future rate, while ignoring the past.
Yes.
Because the future rate may be, in a sense, referable to the past. Does my lord understand what
I do, yes. It just doesn't sound like a distortion to me, that's all.
I understand it. I understand it. The point is that it may be a distortion. It may be right that it may be that what the judge is getting at is one can't take that as the right rate because it is inflated to deal with the fact that the past has been dealt with in a different way. Okay. That's the point. Whether the language distortion is correct is a more semantic question. It's more, you can't take that as the reliable figure. So that is the overall point. And our submission, which Mr. Segan will be reinforcing, is that the judge made a lump sum award, which was, as we pointed out, not far removed from what ID themselves had said would be appropriate, and indeed in accordance with industry standards, very shortly before they then withdrew it and commenced the proceedings and were seeking a great deal more. My lords will have picked up from the form of order hearing that my learned friend's contention was that they had won the case on the footing that in late 2018 they had put forward an offer, albeit one that was hedged with all sorts of requirements which made it incapable of acceptance, and which was withdrawn. That was, as was described in the terms of the slides themselves, well within the norms of industry licensing practice, given the strength of the portfolio, and that's at E tab 4, page 40. And so this is not a situation where what the judge did was outside what InterDigital had themselves regarded as appropriate to put forward by way of licensing terms, before they then had essentially a volte-face and said, no, we want, broadly speaking, 3 times as much. So our overall submission is that the judge was able to evaluate the reasonableness of the sum in question against all of the material in question. He considered the basket. He identified a optimal, comparable, and scaled in that way. And in all respectful submission, that was an entirely appropriate thing to do. So having sort of outlined the general terrain, if I can then invite my lords to hear Mr. Segan on some of the very specific points on LG.
My lords, grounds A and B are an invitation, we say an unwarranted invitation, to this court to overturn and replace the central evaluative judgment with which the Fran trial was concerned. The central task for Mr Justice Mellor, as he described at paragraph 4 of his judgment, was to determine the terms of a global FRAND license between InterDigital and Lenovo. And the core dispute between InterDigital and Lenovo in that regard was, of course, the FRAND rate. That was the central reason why the FRAND trial was taking place in the first place. My lords, the judge, after a 17-day trial, after considering 50 bundles of material, 23 statements from 10 fact witnesses, 30 reports from 14 experts, 11 days of live evidence, 760 pages of written submissions, and 5.5 days of oral submissions, reached an evaluative judgment that the FRAND lump sum for the license was $138.7 million. By grounds A and B, InterDigital asks this court, which can at best only go island hopping in that sea of evidence, to reach an entirely different evaluative judgment. Namely, that the FRAND lump sum was instead $388.5 million. That is the sum which InterDigital invites this court, in paragraphs 54 to 55 of its skeleton argument, to find was the true FRAND lump sum. That sum is almost exactly $250 million more, $249.8 million to be precise, than the judge's evaluation. Indeed, it's not far off treble the sum determined by the judge. And it's worth noting in this regard, my lords, that InterDigital is not asking for a remittal for reconsideration by the judge or anything of that nature. Its draft order can be seen in the core bundle at tab 4, page 321. InterDigital asks this court, in paragraph 2, simply to substitute a figure of $517.7 million for the figure of $184.9 million actually ordered by the judge in his order at core bundle tab 1, page 5. And that sum also, of course, reflects a proposed increase in the interest figure from $46.2 million to $129.3 million. So an extra $83.1 million in interest. So in total, InterDigital is asking this court to add $332.8 million to the judge's award, not far off trebling the lump sum. And we submit that there is, with all respect, simply no basis for this court to add such extraordinary amounts, or indeed any amounts, to the lump sum settled by the judge. I shall be submitting that the judge's evaluation, that the FRAND rate was 17.5 cents per unit, was amply justified by and rooted in the wealth of evidence he saw and heard. Indeed, if one is looking for figures which simply cannot be reconciled with the totality of the evidence in the case, it would be the figures of 61 cents per unit prior to adjustment, or 49 cents post-adjustment, that InterDigital now seeks in this court to extract from the LG 2017 license. As I should be submitting, those figures are simply not supportable by reference to the Lenovo 7 as a whole, which the judge held in paragraph 726 of his judgment were the best group of indicators of the value of InterDigital's portfolio. Including critically those licenses, as Mr. Alexander has already adverted to, where past sales were not part of the analysis at all. And as the judge explained in his judgment at paragraph 576, Lenovo's group of comparables accounted for approximately half of all worldwide handset sales from the year 2013 to the second quarter of 2021, nearly 98% of cellular units licensed by InterDigital, and 78% of InterDigital's total revenue in the year 2020. Those licenses simply do not support, we submit, a FRAND rate of 49 cents per unit. And despite that, the invitation to this court is to use figures of 61 cents per unit prior to adjustment and 49 cents after adjustment as the foundation for an entirely different evaluation of the FRAND lump sum from that reached by the judge. And that is not an exercise which we respectfully submit should be entertained.
Can I just ask you a hypothetical question? As we've seen, ultimately the judge concluded that LG was the single best comparable, and that was the basis of his analysis. Mr. Alexander, before you and you now are understandably emphasising the Lenovo 7 as a whole. If hypothetically we came to the conclusion that the judge's analysis based on LG was flawed, can you support his decision by reference to the other six?
Indeed, yes, and we would seek to do so. But I shall be submitting to the court that the analysis of LG most certainly was not flawed. And what is more, of course, my learned friend is entitled to point, as he points, to paragraph 811 of the judgment, where the judge says, I have, in the end, relied on a single comparable. But that is by no means the whole story of the judge's reasoning process. Of course, it is right that the number in the end he extracted of 17.5 cents came from the LG rate adjusted. But as I'm going to be showing the court, when one goes through his reasoning, one sees the judge constantly cross-checking in identifying LG as the best comparable amongst the best group of indicators of the value of the portfolio against the rates in the other licenses. And we'll be coming to this point, but our submission in the end is that by saying that the judge relied alone on LG 2017 to determine the rate, that is not the same thing as saying that the judge's evaluation of the LG 2017 license must have been undertaken without reference to or uninfluenced by the remainder of the Lenovo 7. And in my submission, we'll be coming to this, it's perfectly clear from his reasoning that that is simply not the case. So we say the rate settled by the judge is already justified by the remainder of the Lenovo 7. But my lords, with that by way of introduction, I wanted to deal with 5 principal topics. The first will be the reasons why comparable licenses are generally regarded as the most probative evidence of a reasonable rate.
Well, that's not in dispute. I think you could take that very shortly.
Okay, I'm sure that's right, my lord. The point I want to emphasise, because it's relevant to the past sales point in particular is that it is the coincidence of compromises between the willing licensor and the willing licensee from which the market rate emerges. And I was going to show the court a few cases on that from the Copyright Tribunal. But as my lord rightly observes, I don't expect ultimately that that will be in dispute. The second topic will be what the parties' respective cases based upon comparable licenses at trial actually were. The third topic will be the judge's findings in his judgment. The fourth will be the standard of review on appeal. And the fifth will be the reasons why we say grounds A and B should be dismissed. So turning to the first of those 5 topics, the reasons for focusing upon comparable licenses. The parties were agreed at trial that if appropriate comparable licenses were available, they were in principle the best source of evidence as to a FRAND rate. The references in that regard are gathered together in our closing in bundle B at tab 5, page 541, at paragraph 28. One can see page 541, paragraph 28, that a comparable license analysis was pleaded as InterDigital's primary case on the royalty rates, that Mr Bezant said it was generally the best approach, Mr Meyer agreed.
I'm a bit confused, Mr. Segan. I'm bound to say it. My own view of what it's worth as a matter of principle is that comparables are usually the best approach. I'm startled to see you citing the experts as if that it's a matter for the experts. I thought the question was a question of principle for the court, and you were going to cite authorities.
Well, I'm going to come to authorities.
Okay.
I'm just, my lord, for now, setting out what the parties' respective positions and evidence was. And we can see that InterDigital's own position to the US courts in 2018 had been to that effect. Now, of course, the adoption of a comparable license analysis to assess a fair and reasonable royalty is nothing new. It's been undertaken on many occasions by courts in the damages context and by the Copyright Tribunal. And as I say, the underlying logic is to identify arm's length market transactions and use them as a guide for estimating the outcome of an arm's length negotiation between the parties before the court or tribunal. And as I submitted earlier, the value is that the market values in such licenses are the product of a process of compromise between a willing licensor and licensee dealing at arm's length. And I know this is very familiar to the court, but I just wanted to take the court to some authorities on this. First of all, a couple of cases from the Copyright Tribunal, which are in the joint authorities bundle, volume 1, tab 2, first of all. This is the Scottish Ballroom Association case. It was one of the first, if not, I think the first.
It was the first.
To the, I'm most grateful, my lord, to the Performing Rights Tribunal, which of course came.
You don't find this out from the decision, you have to find it out from elsewhere. But it had an interesting composition. The chairman of the tribunal at this time was Walter Rayburn, QC. One of the members was Dame Alex Meynell. And for those who don't know who she was, it's worth looking up.
I'm most grateful, my lord. Whether that's lunchtime or this evening, I don't know, but we'll certainly have a look at it.
No, it's not relevant to the issues in the case. It's for general interest.
This evening, then. My lords, this concerned the reasonableness or otherwise of the PRS tariff for dance halls. And as often happens, the dance halls relied on a prior agreed tariff as evidence of a reasonable tariff. And we can see on page 4, in the second paragraph onwards, that the PRS pointed to an analogy of the owner of a patent or the author of a book. That didn't commend itself to the tribunal. But that doesn't matter for my purposes, because all I'm interested in are general observations about comparables in the next paragraphs. In the present case, the PRS is the seller, the dance hall proprietor is the buyer. As in the case of any commodity into which the cost of production does not enter, the value is fixed by discovering how much the buyer is willing to pay and how little the seller is ready to take. That is to say, it depends on negotiation on equal terms. Then there's reference to the history of the negotiations and the various points that were put forward as to why one or other side was in a stronger position. And then the tribunal says, it seems to the tribunal that in truth these counterbalancing factors cancelled each other out, and that what really operated was, on the one side, the eagerness of the PRS to preserve and extend the outlet for its members' music, and on the other, the need of the dance halls to acquire the right to perform that music. Here then was a typical coming together of the willing buyer and the willing seller, out of which, as a matter of plain economics, the value of the commodity emerges. And I derive the same point, but with particular emphasis on the coincidence of compromises from the ITV case, which is at tab 9 of the same bundle, page 75. This was a dispute between ITV and PRS about the then licensing scheme for independent television channels. There was an extensive history relied upon by the independent television companies, as one sees from paragraph 21 at page 91. Mr Stamler submitted that the best evidence of a fair and reasonable royalty is what the parties themselves agreed, particularly when there was not merely one set of agreements, but a long and consistent course of conduct. And the point about the coincidence of compromises I derive from paragraph 45 at page 112. In the view of the tribunal, it is impossible to ignore the significance of the negotiations and agreements between the two sides over such an extended period of years. Basically, those agreements were, in the view of the tribunal, arm's length, freely negotiated commercial agreements, and represent, in the tribunal's opinion, the coincidence of those compromises which commercial men make to reflect all of the factors which they consider relevant when they in fact reach commercial agreements. So the coincidence of compromises between willing buyer and willing seller. I then refer to the CSC case, which is in tab 16 of this bundle. This is another case which started, at least in the Copyright Tribunal. This was a dispute between CSC and VPL about a reasonable royalty for a license to include VPL's music video repertoire in CSC's television channels. Paragraph 10 at page 320 records the point that, as I know the court will be very well aware, the statute according to which the Copyright Tribunal has to act that specifically requires regard to comparable licenses. There is a reference in paragraph 19 on page 323 to a point about the uncertainties of settling a reasonable royalty rate based on comparable licenses by citation from the Cimetidine case, Lord Justice Nichols. And I shan't read that whole passage out, but I do invite my lords to read it. So my lords, recognition that this is an exercise where reasonable decision makers can differ without falling into error. And in relation to the correct approach, at paragraph 71, page 335, in fact, I can go straight to paragraph 73. I do not accept the proposition if the judge intended to advance it in paragraph 52 of his judgment that the only legally valid way of dealing with such a dispute in the present one is by starting with the most relevant comparable and adapting it to the circumstances of the case. Plainly, that is a logical approach and probably the one most likely to ensure a correct answer. And then there's reference to Lord Justice Lloyd in the Cimetidine case. Where close comparables exist, they provide by far the best and surest approach. There is no better guide to what a willing licensor and a willing licensee would agree than what other licensors and licensees have in fact agreed in comparable cases. Finally, my lords, Unwired Planet. That is in volume 2 of the Authorities Bible, at tab 18. And at page 414, paragraph 170, my Lord Justice Birss dealt with the relevance of comparable licenses in determining what was frowned. And I shan't read that whole paragraph out, but again, I would invite the court to consider it. And my lords, the point is made in the last couple of sentences that, like any real situation, many factors may have been in play, and that the negotiations may have involved a greater or lesser degree of hold-up or hold-out, and that, of course, is something that the courts have been very much alive to.
So, what do you say about what my Lord Mr Justice Birss, as he then was, went on to say in 175, particularly towards the end of 175?
Yes, my lord. Well, this is an important factor in this case for reasons which emerge from the so-called Fjord graph, which I'm going to be coming to, which we reproduce in our skeleton argument. Because what had happened in this case, without descending to the specifics, is that InterDigital had concluded a large number of licenses with very small licensees at rates far higher than the rates that were being charged to the major players in the industry.
Yeah, well, that's part of the reason why the interdigital twins are of no use as a comparable.
Yes, my lord. And so this, and so the situation Mr Justice Mellor was really faced with when one looks at that graph, based on the cases that were actually advanced at trial, InterDigital said the true Fran rate is the rate being paid by the 20 at the far end, who for various reasons were really very poor comparables, and that everyone else was getting a discount. And they saw, we'll be coming to this, there's an extended discussion of this issue in the judgment, that the way that InterDigital advanced of rationalising the other licenses was to say, well, they're all getting a huge discount. And the judge, after extended consideration of that, rejected that submission and held that those discounts were simply a way of rationalising lump sums hammered out between a willing licensor and licensee in negotiations. And those were the licenses from which the true value of the portfolio emerged. So this issue of discrimination against small licensees was a really important issue in the case.
Absolutely, and I understand that. And you, as you've explained, you rely upon that. But more generally, would you accept that the court's task is to, as my lord put it, set the Fran rate at primarily by reference to the value of the patents being licensed, with the result that all licensees who need the same kind of license will be charged the same kind of rate. In other words, it should be a rate which ignores non-Fran factors, of which the size of the licensee is an example.
My lord, I don't disagree with the proposition that the task is to settle a license which embodies a Fran royalty. I don't disagree with the proposition that it therefore has to be determined primarily by reference to the value of the patent being licensed. The central question for the judge was which licenses were evidence of that. And he was faced with competing cases whereby InterDigital's case at trial was the only indicators of the value of the portfolio were the tiny ones up the far end, the cliff in the field. And everyone else was getting a non-Fran discount. The judge, for reasons explained over many, many paragraphs in which I'll be taking the court, rejected that and found specifically that the lump sums embodied in the Lenovo 7 were Fran. There was no basis for supposing that they were other than, or that they were massively below, which had to be InterDigital's case, the true value of its portfolio. So, my lord, in the end, excluding these tiny licensees had very little effect. There's no appeal against the finding that they were not appropriate comparables anyway. But the key point is that the Lenovo 7 accounted for 98% of the units under license by InterDigital. So that was the market rate. And as we're going to be seeing, if you simply did a blended analysis, you just take the number of units covered by the license and use that to divide up the total lump sum consideration, the figures you got were remarkably consistent. It was only when, and this comes out with the Norwich City graph that we'll be coming to, it was only when you introduced an attempt to rely on future-only rates in respect of those licenses where there is a division between past and future, that you started seeing rates which make no sense by reference to the body as a whole, and make no sense specifically by reference to the licenses where there were no past sales at all. But I'm running ahead of myself here. I'll be developing those points in some detail. Just to make good the point that Mr. Alexander made about the process that...
Have we finished on the authorities?
Not quite, my lord. I wanted to show the court, very briefly, the process that my Lord Justice Birss followed in this case. We can see at paragraph 197 at page 420. One needed to determine what E, R, and S were. And that was because, as we will be seeing, the two unwired planet comparable licenses, so the direct comparable licenses. Neither of them was actually a good comparable. And because the Unwired Planet portfolio had been carved out from Ericsson's portfolio, therefore the licenses that were used were in fact Ericsson comparables, which introduced the whole question of how to scale to the size of Unwired Planet's portfolio. And the portfolio strength issues are dealt with all the way from paragraph 198 through to 381. Then at page 456, paragraph 382, the court began the analysis of the comparables in this case. And the following paragraphs all the way through to 467 analysed the 11 Unwired Planet and Ericsson licenses in considerable detail. At 420, well, let me just show the court. Page 462, the Ericsson Samsung 2014 licence was considered. And the relevant point is over the page in the conclusion at 420. The court found that standing back, this licence represents a solid piece of evidence of what reasonable people in the industry would do. Two parties have broadly equivalent economic strength, freely negotiated. There was litigation before Ericsson and Samsung before it was agreed, but I doubt parties of the size and sophistication of these two were troubled by that. This licence is solid evidence from which one can infer what a fair and reasonable value of the portfolio under licence might be. The same point about smaller licensees is picked up at paragraphs 443 and 445. There were three smaller and more geographically limited licenses. And at 445, in the last sentence, what one can see is that Mr. Lazinski has explained that he thought it was unlikely parties of this size would conduct sort of detailed negotiations one saw as between the bigger players. I accept that up to the point of facts to bear in mind when placing weight on rates in these licenses, but looked at another way is a reflection of the inability of smaller licensees to resist hold-up. At 462 on page 467, the court identified 6 licenses on which it was prepared to place any weight. And at paragraph 464, the court reached the ultimate determination as to what the appropriate rate was, and said that is arrived at by looking at the range of unpacked rates of the Q license, starting from the top of that range, and adjusting upwards by a factor which is, I've arrived at this number and approach after considering all the material. The main reasons for this are as follows. The Q license is the best place to start, etc. So the court identified a basket of 6 licenses upon which it was prepared to place any weight, but ultimately set the benchmark rate by reference to the rates from a single license, the Q license, because that was the best place to start, and then taking into account the other 5 licensees in the basket. So, my lord, what Mr Justice Mellor did in this case was certainly in accordance with what has happened in previous FRAND determinations. But, my lords, the point I emphasise, and as I've emphasised already from these authorities, is it's the process of compromise between licensor and licensee from which the true market value of the rights in question emerges. And there are 2 corollaries of that. The first is that the judge was right in our submission to hold that the subjective or internal views of one party or another to a comparable license as to whether they gave a discount or paid a premium are either irrelevant or else need to be treated with extreme caution. That is a point that the judge made repeatedly at, for instance, paragraphs 374, 422, 426, 553, 560, 563 and 619. The two parties to a transaction will very frequently remain at odds, even after they have agreed a price, what the asset was actually worth or why. If I sell an asset after a hard-fought negotiation where I have had to concede ground, I may well think I have given the buyer a discount. The buyer, by contrast, might well think that he or she has paid a premium. But the rationale of the comparables approach is that unless there is some solid evidential basis for concluding otherwise, the best guide as to the market value is the price at which the transaction was actually concluded. As I say, one needs, in my submission, a very solid evidential basis before departing significantly from that agreed value. That's the first corollary. The second corollary, which is of perhaps greater direct relevance to the issues in this appeal, is that a court should be very cautious, in our submission, about an invitation to salami slice the overall consideration under a comparable license and ignore part of that consideration. The evidence in this case was that when hammering out a lump sum license, implementers do not generally care how the SEP owner justifies whatever concessions it makes on the lump sum. They just care about the top line figure. That's paragraphs 147 of the judgment and paragraph 779, subparagraph 3. What is more, the evidence was also that in the to and fro of negotiating a lump sum, a SEP licensor will often seek to rationalise a reduction in the lump sum being offered as a discount on past sales. You see this, for instance, in Mr. Merritt's evidence at paragraph 393 of the judgment. And by comparing his evidence to Mr. Javahirian's, one can see the different perspectives of different sides of the negotiation. Mr. Merritt's evidence is page 114 of the court bundle, at paragraph 393. He makes reference to the difficulties in recovery of past sales and such like, limitation periods. And his third point at the end of that paragraph is perhaps because of this, past sales have typically been in licensing negotiations the area where the licensor can be most flexible, and this was widely understood among licensing professionals. Mr. Javahirian, who was a licensing professional, gives his perspective at paragraph 396, page 115.
Yeah, but I'm not sure why you're relying on that, given the judge rejected it in robust terms at 397.
Well, my lord, I rely on it simply as evidence of what actually happens in these licensing discussions. The question of
the
what
judge has found it's not friend.
Well, my lord, I'm going to come to the question of what is friend or otherwise in the context of these licensing discussions. Well, the only point I'm seeking to extract as a factual proposition at this stage, my lord, is that in these discussions, movement on the lump sum is often rationalised as a discount on past sales. And against that background, if you attempt to divide a lump sum into two different amounts and then carve out past sales altogether, which is the only proposal that InterDigital ever made to deal with the effect for which it contends, an important point that I'll be coming back to in due course. The only proposal was ignore the past altogether, take only the future rate, which is logically inflated to a precisely correlative extent as whatever unfair deflation has occurred in the past rate, as has already been referred to in argument. That was their only proposal as to how to deal with this. If you do that, you are excluding the very area where the licensor at least conceives itself to have made the concessions which resulted in a market value embodied in the lump sum in the first place. A reasoning process about which the licensee, on the findings of the judge, does not ultimately care, being focused only on the lump sum. And this was a point that Mr Javaharian made when he was cross-examined about this issue, and I can do this point very quickly before the short adjournment. This is bundle D at page 180. Tab 6. Page 1069. And after a short break, Mr.
I
Javaharian.
thought you told us we shouldn't be idle and hopping amongst the evidence.
My lord,
you seem to be delving into some cross-examination here.
It's a fair point. I hope it's not unduly cheap for me to say that faced with the case that's made against us, in a sense, I have no option.
All right, fair enough.
My lord, after a short break, Mr. Speck asked various questions to Mr. Javaharian about the effects of delay and in relation to the effects of delay on rates for past sales. And we can see on page 1070 at line 6, the delay causes that pressure on licensors, and that is what they do, that is right, is it not? If a licensor has a rate that's too high, in order to find agreement on a rate that is believed to be frowned, the licensor lowers its price. It can do that in lots of different ways, whether that is by limiting past sales, whether that is by lowering the rate, whether that is by some other mechanism, really is irrelevant to the economics of the deal. There's then a further question about the effect of delay. And Mr. Javaharian says, no, I do not know that the result is the item that follows from the assumption that you are making, which is the intention or cause of the result. In other words, you are saying the delay is what is causing concessions in a negotiation. Yes, as in any negotiation, the concessions can be the result of negotiations that lead to the market price, as opposed to some sort of other approach which is taking away value that is otherwise owed. So, my lord, he's making the point that concessions in relation to past sales might result from pressure caused by delay or holdout, but they might simply be a way of the licensor lowering the rate to arrive at a frown market rate. And so we say it cannot be assumed that if parties refer to or even agree, to pick up my Lord Justice Nugee's point, some form of concession on past rates, that it can be inferred necessarily that that was non-frowned or results in a non-frowned lump sum, nor indeed did the judge make any such finding. Rather, one has to look at the overall circumstances of the conclusion of the licence to work out whether the lump sum was in fact the product of non-frowned factors. And that is a task that the judge undertook, as we should be seeing, for each of the Lenovo 7. And he found that there was no evidence that the Lenovo 7 imply rates far below the true value of InterDigital's portfolio. That's paragraph 726 of the judgment. My lords, I think that's a convenient moment.
Thank you. We'll resume at 2.
Can I please remind the courtroom that the live stream is still running?